Here's something that could completely reshape how Irish businesses handle their workforce. Thousands of employers who have been classifying workers as independent contractors might be sitting on a tax compliance time bomb. And Revenue just threw them a lifeline that expires in January 2026. But here's where it gets controversial. This settlement opportunity essentially admits that the previous guidance was so unclear that even well-intentioned employers got it wrong. So who's really to blame for this mess? The employment classification revolution that changed everything. Irish employment and taxation law experienced a seismic shift following a landmark Supreme Court ruling in the Karshan case, also known as the Domino's Pizza case. This wasn't just another legal decision. It fundamentally rewrote the rulebook for distinguishing between employees and independent contractors. For those unfamiliar with the legal jargon, think of it this way. Imagine you've been paying someone as a freelancer, but legally, they should have been treated as your employee with all the associated rights, benefits, and tax obligations. The Karshan judgment introduced a comprehensive 5-step assessment framework that made these distinctions clearer, but also revealed that many existing working arrangements might have been incorrectly classified. Following this judicial earthquake, an interdepartmental working group comprising the Department of Social Protection, Revenue, and the Workplace Relations Commission collaborated to produce an updated code of practice on determining employment status. Additionally, Revenue published its own specialized guidelines for taxation purposes, creating a more robust framework for compliance and risk management. Revenue's unprecedented settlement offer. A golden opportunity or admission of systemic confusion. In an almost unprecedented move, Revenue has announced extraordinarily generous settlement terms that allow employers to correct payroll taxation issues for 2024 and 2025 arising from genuine employment classification errors, without facing the typically harsh penalties and interest charges that would normally apply. Here's what makes this offer remarkable. Revenue is essentially acknowledging that employers who acted in good faith, relying on the legal precedents and guidance available before the Karshan decision, may have inadvertently misclassified genuine employees as contractors. This represents a significant departure from Revenue's typically strict enforcement approach. But here's the part most people miss. This amnesty-like arrangement comes with a critical deadline. Employees have until Friday, 30 January 2026 to voluntarily disclose any relevant misclassifications. After this date, any discovered liabilities will attract the full weight of Revenue's enforcement powers, including substantial penalties and interest charges. Revenue has also published comprehensive guidance in a new tax and duty manual specifically addressing this settlement opportunity, providing employers with detailed instructions on how to navigate this complex process. The settlement framework. What's included and what's definitely not. The settlement terms apply specifically to payroll tax discrepancies for 2024 and 2025. But, and this is crucial, they come with significant limitations that could catch unwary employers off guard. The arrangement explicitly excludes several categories of workers. First, second, workers who should have been classified as employees based on any published decision from the Department of Social Protection, the Workplace Relations Commission, the Tax Appeals Commission, or any court are also excluded. In other words, if there was already clear legal guidance indicating employee status, ignorance isn't an acceptable defense. Third, any compliance intervention that was already underway before the Karshan judgment on 20th October 2023 remains outside the scope of these favorable terms. Calculating your tax liability. simplified methods for complex situations. Revenue has streamlined the calculation process, recognizing that retrospective PAYE calculations can be incredibly complex. Instead of requiring employers to reconstruct detailed payroll records dating back months or years, they've introduced simplified calculation methodologies. For income tax purposes, employers can apply a flat 20% rate to the gross payments made to affected employees during the relevant tax year. This represents a significant simplification, as it eliminates the need to determine each individual's specific tax rate, which could vary based on their other income sources and personal circumstances. Universal social charge calculations are even more streamlined, with revenue accepting a blended rate of 3.5% applied to the gross annual payments. This approach recognizes that determining the exact USC liability would require detailed knowledge of each employee's total annual income from all sources. However, PRSI contributions must be calculated on an actual basis, with both employee and employer contributions properly determined and PRSI records created for each affected individual. This requirement ensures that employees don't lose out on social welfare entitlements due to the misclassification. Revenue has also addressed the potential double taxation issue that could arise if employees have already filed self-assessment returns for 2024. In such cases, credits will be available for taxes already paid, though Revenue indicates they'll handle these situations on a case-by-case basis. The disclosure process, transparency and documentation requirements. Employers seeking to avail of these settlement terms must provide Revenue with comprehensive documentation and a clear explanation of why they believe the misclassified workers fall within the scope of the arrangement. Critically, they must demonstrate that any misclassification resulted from genuine uncertainty rather than careless or deliberate behavior. For each affected employee, employers must supply detailed information, including full names, personal public service numbers, employment start and end dates, total payments made in both 2024 and 2025, and calculations for income tax and USC using the simplified blended methodology outlined above. Once Revenue accepts the disclosed liabilities, they'll process the income tax, USC, and PRSI for 2024 through a PAYE assessment in November 2024, with 2025 liabilities assessed in November 2025. Following this assessment, employers must manually create PRSI records for each employee to protect their social welfare entitlements. Payment arrangements, flexibility with conditions. All liabilities should ideally be paid in full through Revenue online payment system. However, recognizing that some employers might face cash flow challenges, Revenue will consider phased payment arrangement requests submitted alongside the initial disclosure. It's important to note that opting for a phased payment arrangement isn't penalty-free. Interest charges will apply throughout the settlement period, though this is still significantly more favorable than the penalties that would apply outside this settlement framework. The high-stakes consequences of inaction Revenue has made it crystal clear that this settlement opportunity represents a limited-time offer with severe consequences for non-compliance. Employers who fail to make relevant disclosures by the 30 January 2026 deadline and whose liabilities are subsequently discovered will face the full force of Revenue's enforcement powers. This isn't just about paying the outstanding taxes. Revenue will treat such cases as a complete failure to correctly operate PAYE, PRSI, and USC systems, potentially resulting in substantial penalties that could far exceed the underlying tax liabilities. The controversial reality: who bears responsibility for this mess? Here's where this situation gets genuinely contentious. If the employment classification rules were clear enough, why is Revenue offering such generous settlement terms to thousands of employers who apparently got it wrong? Some argue that this settlement opportunity is essentially an admission that the previous legal framework was inadequately defined, leaving well-intentioned employers to navigate murky waters without clear guidance. If this interpretation is correct, should businesses really bear the full financial burden of regulatory uncertainty? Conversely, critics might argue that employment law has always provided sufficient clarity for those willing to seek proper advice, and that this settlement simply rewards employers who cut corners on compliance to gain competitive advantages. And this is the part most people miss. The broader implications of this settlement extend far beyond immediate tax liabilities. It effectively creates a two-tier system where employers who proactively disclose potential issues receive preferential treatment, while those who remain silent face much harsher consequences if discovered. The strategic imperative for immediate action. For employers currently engaging workers on a contractor basis, this settlement opportunity represents a critical decision point. The window for favorable treatment is rapidly closing, and the consequences of miscalculation extend far beyond financial penalties. Employers must urgently review their workforce arrangements against the updated legal framework, considering not just the immediate tax implications, but also the broader employment law consequences. This includes potential claims for employment rights, holiday pay, and other statutory entitlements that misclassified workers might pursue. The documentation requirements for disclosure are substantial, requiring employers to compile detailed records that may span multiple tax years. Organizations should begin this process immediately, as the administrative burden of preparing comprehensive disclosures could take months to complete properly. Expert legal and tax advice becomes essential in these circumstances, particularly given the complexity of demonstrating that any misclassification resulted from genuine uncertainty rather than deliberate noncompliance. Looking forward, the new compliance reality. This settlement opportunity marks a fundamental shift in how revenue approaches employment classification compliance. Moving forward, employers can expect much stricter enforcement of the updated guidelines with limited tolerance for classification errors. The Karshan judgment and subsequent guidance have essentially eliminated many of the gray areas that previously allowed for different interpretations of working relationships. This increased clarity comes with heightened responsibility for employers to ensure proper classification from the outset. Organizations should implement robust review processes for all contractor arrangements, ensuring that classification decisions are properly documented and regularly reassessed as working relationships evolve. What do you think about this settlement arrangement? Is revenue being appropriately generous in acknowledging the previous regulatory uncertainty? Or does this create unfair advantages for employers who failed to seek proper guidance initially? And here's the bigger question. Should employers who invested in proper legal advice and got their classifications right feel disadvantaged compared to those receiving favorable settlement terms? This situation raises fundamental questions about regulatory clarity, business responsibility, and the fairness of retrospective compliance arrangements that deserve serious discussion in the business and legal communities.